You guys all have a level? Thank you all for coming on what's turned into an unusually busy Monday. I'm here today to let you know that Progress Ohio and our fellow plaintiffs, Representative Murray and Senator Skindell, have filed on Friday late in the afternoon an appeal to the Ohio Supreme Court. This issue started as just an issue about JobsOhio, and I still think it's important that JobsOhio be decided on its merits. No court has yet to rule on its merits of using public money in a private corporation. But it has grown into something bigger. It has grown into an issue where this issue of standing has been used, not just in this case, but it's also been used in the case of the Lottery Commission against the Ohio Roundtable, in a way in which the public is not permitted to file a lawsuit against something potentially unconstitutional. In my view, that leaves our Ohio Constitution essentially defenseless. It means that we will never know if something like this stands, whether provisions of the Ohio Constitution are being violated. So this appeal at this point in time really is not just about JobsOhio, it is about the standing issue. As such, as many of you know, the Ohio Roundtable, which I've discussed often with because of our stance on our concerns about gambling, is in a situation where they're going to have to appeal over their standing issue. After the 10th District Court decision, Maurice jotted me an email and indicated his concern about the standing issue. I let our lawyers sort of do their lawyering here, but I believe that on this issue, it is not a partisan issue, it's not an ideological issue, it's an issue in which the best interests of the state of Ohio are that our Ohio Supreme Court allows for lawsuits to protect our Constitution. I'll answer questions more about the lawsuit itself. By the way, the press release is going out and it has a link to the actual case. But I'd like to bring Maurice up. Let me just say before he comes up, I know that we're not often always on the same side. But I can tell you in our 6 years at Progress Ohio, this is not the first time we've reached out to groups that traditionally haven't been the same ideology as us. That includes issues on casino gaming. I believe I did a press conference with Coast at that point in time. And other issues, including some of the Tea Party folks who worked with us on our anti-escalation in the Iraq War. As some of you know, the Ron Paul supporters had equal concerns about the Iraq War and the Afghanistan wars. So this is not inconsistent with things that we've done in the past, although I would say that probably in the next few weeks or days, or probably sometime today, I've done something that Maurice wouldn't agree with, and I'm sure he's probably in the same position. So, but that's what is required when you're working on behalf of the citizens of this state, and you're representing people that can come to agreement on different issues. And in this case, we agree on the standing issue. So, Maurice?
Thanks, Brian.
Sure.
The distinct pleasure of saying that everything that Brian Rothenberg just said was completely true and accurate, and I agree with it. So record that, and you'll probably use it in relation to some other issue in the future. I know how some of you are with that, but that's absolutely true. The reason that I contacted Brian after his decision is that the 10th District's decision was absolutely abysmal in every way imaginable, and this issue is such a critical issue because standing is the gateway to vindicating all of our other constitutional rights. So in many ways, standing is actually more important than any one single constitutional right in the state. We all have our favorites that we think are important, but standing trumps all of those, because if you can't get into court to vindicate them, then nothing else matters. And probably over the past 20 to 30 years, but particularly over the past 5 to 10 years, we've seen a dramatic degradation of standing jurisprudence in Ohio, beginning with a case called Brinkman out of the 12th District in 2007, where citizen standings to challenge general government spending, general government indebtedness, and corruption has just continuously eroded. And it's of great concern to us because, as you know, our organization focuses on the Ohio Constitution and the ways it is unique, different, and in some ways better than the federal Constitution. And we're disgruntled because standing is one of the ways that it is unique and better than the federal Constitution, and yet the decision in the Progress Ohio case relies solely upon the federal Constitution to find that Progress Ohio lacks standing. So, in short, the federal Constitution has this Article 3 cases and controversies requirement. And if you look at the 10th District's decision, they give a lengthy block quote that relies almost exclusively on federal case law for the proposition that Progress Ohio lacks standing. We have a problem with that because the Ohio Constitution contains no similar hurdle to standing. There is no cases and controversies requirement in the Ohio Constitution. Now, in that case, the court goes on to consider some state issues, and we also believe they're dead wrong and have to be found by the Supreme Court to be dead wrong on those issues. Let me briefly chronicle why those are so important to us. Basically, the analysis is this. Does the plaintiff have a personal stake in the matter? And if not, is it a case of sufficient public interest? Well, in the 10th District's holding that Progress Ohio doesn't have a personal stake in the matter, what they've essentially done is say that no Ohioan can have a personal stake in controlling its government when it's out of control in terms of government spending, government indebtedness, government taxation, anything else that doesn't affect you uniquely in a personal manner. So what they've essentially done through the personal stake requirement is to read those parts of the Constitution out of the Constitution. They've essentially redacted Article 8, redacted Article 13, because if you can't enforce them, their words don't matter. And that's a serious problem. Now, there is this exception where an Ohioan does not have a personal stake, and that is the public right or the public interest exception. And what the 10th District did in the Progress Ohio case is equally pernicious on that front. What they did is to hold that there are certain kinds of constitutional rights that are of sufficient public importance, but guess what? Certain other kinds of provisions in the Ohio Constitution are not of sufficient importance. And if there is any provision in the Ohio Constitution that is of significant importance, sufficient to give rise to public interest standing, it is Article 8, and it is also Article 13. Why do I say that? Well, I say that because Articles 8 and 13 are the very provisions that gave rise to the Constitutional Convention of 1851 in response to this runaway train of corporate welfare that we experienced in Ohio in the 1830s and 40s. So these are the very parts of the Constitution that precipitated the Constitutional Convention that led to the Constitution that we have today. So these are arguably the most important parts of the Constitution. So for judges to pick and choose and say, well, if it's a violation of Article 4 when it affects the judiciary branch, we're going to find public interest. But when it's Article 8 or Article 13, we're not going to find a public interest. These are just judges subjectively imposing their own personal preferences on deciding who can access court and who can't. And that's dead wrong. And if Progress Ohio doesn't win on the standing issue here, ultimately we have very little recourse to rein in government spending within its constitutional confines, to rein in state corporate welfare within its constitutional confines, and to rein in indebtedness within its constitutional confines. So we think this is an absolutely critical case, and we're eager for the court to take it and to support them in however we can. I'll take any questions.